Good afternoon, everyone, and for those participants logging in today from the Central and Pacific time zones, good morning. Welcome and thank you for joining us. Today's webinar will cover the Public Utility Regulatory Policies Act of 1978, or PURPA, and is entitled PURPA Policies, Then and Now, the Latest Developments for Electric Utilities. My name is Meg McNall, and presenting with me today are my colleagues Rebecca Shelton and Peter Matt. We are attorneys in Thompson Coburn's utilities practice area, and we advise electric utilities on PURPA compliance matters. Before we turn to our presentation, I'd like to review a few logistical details for the webinar. First, for those of you who are attorneys and in need of CLE credit, this webinar is CLE certified. Thompson Coburn will send CLE certificates once we verify your attendance at this webinar. Second, if you are seeking CLE credit, we have a procedure to verify attendance. During the webinar, 3 code words will appear. They'll each be posted on a separate standalone slide from the presentation. When these words appear, please write them down. You will include them in the verification form included in the login instructions that you received for the webinar. Your webinar login is proof of attendance at the CLE. If you need to leave the webinar, please log out and then log back in when you return so that we can keep accurate time records for attendance purposes. If you have any CLE-related questions for Thompson Coburn, please send those questions to cle-tc@thompsoncoburn.com. Our presentation today is divided into 2 parts. We'll first provide an overview of PURPA and some of its principal requirements. Those of you who either practice law in the energy sphere or who work with electric utilities may already be a little bit familiar with PURPA, and if you are, you know that PURPA is extremely complex. While we're all, I think, anxious to dive into our discussion of current issues dealing with PURPA, of which there are many, we wanted to spend some time first covering the basics of PURPA. Once we've laid that foundation, we'll begin our discussion of current issues and then conclude with a few thoughts about where we may be headed in terms of the legal and regulatory landscape for PURPA moving forward. Here we have some relevant legal citations, including to the PURPA statute. PURPA is administered by the Federal Energy Regulatory Commission, and we refer to this commission throughout our presentation using the acronym FERC. This slide also includes references to pertinent sections of the FERC regulations and key FERC orders that implement and establish FERC's PURPA policies and regulations. Any overview of PURPA would be incomplete without a discussion of the 1970s era energy crises. In the United States, throughout the late 1960s and early 1970s, demand for electricity was steadily increasing as our economy and population grew and expanded. By the early 1970s, we were relying on petroleum to generate roughly 16% of our electricity. Just as an aside, petroleum comprises less than 1% of our fuel mix today, so the landscape in the late 1960s and early 1970s was quite different in that regard. Our reliance on petroleum products at that time, and in particular on petroleum imports, in the early 1970s became both an economic problem and a national security concern when, in the fall of 1973, a subset of members of the Organization of Petroleum Exporting Countries, or OPEC, implemented an oil embargo against the United States, Great Britain, Canada, and several other countries. This was as a result of certain geopolitical conditions that were happening in the Middle East at the time. Even though the embargo itself lasted only a few months, its impacts resonated throughout the U.S. economy for much longer. The embargo caused petroleum prices to spike from around $3 per barrel to over $12 per barrel, and those prices stayed pretty high even after the embargo was over. At the same time, and this is kind of hard to believe now when our country is experiencing record low natural gas prices, but there were real concerns in the 1970s that our country's supply of natural gas was running out. In the 1970s, natural gas was used to generate about 14% of our electricity. And just by way of comparison, I think it's over 30%, close to 35% now. So again, that is something that has certainly changed since the late 1970s. Although the first oil crisis occurred in 1973, it wasn't until the Carter administration in the late 1970s that energy legislation became possible. The focus continued to be on addressing perceived shortages in oil and natural gas. And here we have President Carter identifying some of the drivers for the energy legislation that would eventually become PURPA. So PURPA was enacted as one act within a five-part piece of omnibus energy legislation entitled the National Energy Act of 1978. This act included the Energy Tax Act, the National Energy Conservation Policy Act, the Power Plant and Industrial Fuel Use Act, and the Natural Gas Policy Act. So it was really a very wide-ranging law that covered a lot of different things, but its primary focus was really on, and the primary focus of PURPA was really on trying to cultivate domestic sources of energy, including energy from renewable resources, and somewhat different as compared with today, also trying to encourage increased reliance on coal, which was seen as a domestic fuel source that was more energy secure than petroleum at the time. When the National Energy Act was passed, according to the Speaker of the House of Representatives at that time, Tip O'Neill, he said, this is one of the most important pieces of legislation to have passed the Congress of the United States, I would say, in a century. And that century would include the Federal Power Act, so that's a pretty strong statement. 40 years later, what those of us in the energy industry generally mean when we refer to PURPA is actually one section of PURPA. It's Section 210. Under Section 210 of PURPA, electric utilities are required to buy power from certain types of generating facilities called qualifying small power production facilities and qualifying cogeneration facilities. The price for these purchases is described in the statute as, and I'm quoting, the cost to the electric utility of the electric energy, which, but for the purchase from such cogenerator or small power producer, such utility would generate or purchase from another source. We refer to this very lengthy cost description as the electric utilities avoided cost. In terms of its applicability, PURPA applies to electric utilities. As defined in the statute, this is any person or state agency that sells electric energy. Under the statute, there are no exclusions for non-public utilities under the Federal Power Act. This means, as a practical matter, that most municipal utilities and rural electric cooperative utilities that are normally exempt from most areas of FERC's jurisdiction under the Federal Power Act are actually subject to the requirements of PURPA, including the must-purchase obligation. As I mentioned just a moment ago, under PURPA there are two types of qualifying facilities, or QFs, that are allowed to make sales to electric utilities at avoided cost rates. First, qualifying small power production facilities are generating facilities that use biomass, waste, renewable resources such as wind or solar, or geothermal power as their primary fuel source. Qualifying small power production facilities may not exceed 80 megawatts in size. Second, cogeneration facilities produce electric energy plus thermal energy such as heat or steam. There's no maximum size applicable to cogeneration facilities, although the thermal output of the facility must be used in a productive and beneficial manner. For example, one might find a cogeneration facility on an industrial site, such as a paper mill or an oil refinery. The heat or steam produced by the facility is used in connection with a manufacturing or refining process, And the electric energy is also used to supply the needs of the industrial site, with any residual being eligible for sale to the electric utility. Importantly, with respect to cogeneration facilities, the facility's fundamental purpose can't be making electricity sales for resale. The primary purpose of the facility has to be some other usage in connection with an industrial purpose. In addition to meeting FERC's size and fuel requirements, QFs must satisfy other parts of FERC's regulations. Unless they're 1 megawatt or smaller, QFs must be certified with FERC. This certification requirement can be accomplished through either a self-certification using a FERC form, the reference is provided there, or a filing seeking commission certification. The purpose of the certification is to document that the QF meets the Commission's size and fuel requirements for qualifying status and to provide certain other information regarding the utility. As a practical matter, most QFs use the self-certification approach as opposed to a formal filing seeking commission certification. When they file either a self-certification form or a petition for commission certification, QFs are required to serve notice of the filing on any transacting electric utilities. That's a step that sometimes can be overlooked. FERC's self-certification requirement is more than a mere formality. If a QF fails to certify its status as a QF and subsequently make sales to an electric utility, FERC can impose financial penalties, and that can include, for example, payment of the time value of revenues received during whatever period the QF was making unauthorized power sales. This remedy derives from Section 205 of the Federal Power Act. The thinking there is that while QFs are normally exempt from rate regulation under the Federal Power Act when making sales pursuant to PURPA, this exemption doesn't apply when the QF has failed to certify its status to the Commission. And for those seeking CLE credit, we have our first code word. Please write it down. Let's focus a bit more on the must-purchase obligation under PURPA. As I mentioned previously, PURPA imposes on electric utilities a mandatory requirement to purchase energy and capacity made available by a qualifying facility at the electric utility's avoided cost. Under FERC's regulations, purchases can be made on an as-available basis, which is similar to an energy-only type of concept, or pursuant to a legally enforceable obligation. A legally enforceable obligation generally refers to the right of a QF to sell its output to an electric utility, and it typically means some form of a long-term contract or power purchase agreement. As a practical matter, QFs prefer the legally enforceable obligation option because it provides greater certainty for financing purposes. Importantly, it's up to the QF to decide which of those two options they would like to select. If a QF invokes its right to make sales to an electric utility pursuant to the legally enforceable obligation, then the avoided cost rate may be set either at the time the legally enforceable obligation is established or at the time the QF begins making deliveries. Again, the choice is the QF's to make. One issue that's arisen somewhat frequently with FERC is whether a legally enforceable obligation can arise prior to the parties executing a formal power purchase agreement or other type of agreement, such as maybe an interconnection agreement with the QF resource. FERC has said that legally enforceable obligations may, and as a practical matter they generally do, arise well before contracts are signed, so that's something to keep in mind. Consistent with their obligations to purchase the output of qualifying facilities at avoided cost rates, electric utilities are likewise obligated to make available certain system cost data upon request, data that would allow the electric utilities' avoided cost rates to be derived. FERC's regulations are highly specific as to what the system cost data that's made available needs to include. It's things like estimated avoided costs for energy over a 5-year time period, planned capacity additions, anticipated retirements, et cetera. Smaller utilities, which would include those that make 500 million kilowatt hours or less in retail sales each year may provide comparable data to what's specified in the regulations. Electric utilities that are parties to all requirements power supply contracts, as frequently happens with municipal utilities or rural electric cooperatives, these entities may provide their suppliers system cost data and the rates at which they purchase energy and capacity. Again, the purpose of making the data available is to allow parties to understand what an electric utility's avoided costs would be. Avoided costs may be established using a variety of methodologies that have evolved over the years, and we could probably spend an entire webinar just on issues around avoided cost derivation. As a general matter, avoided costs are those that an electric utility would incur but for the purchase from the QF. For electric utilities that are regulated by states, the state regulatory authority would establish the avoided cost. For non-state regulated electric utilities like municipal utilities and rural electric cooperatives, those utilities' local regulatory authorities, such as, for example, the City Council, have jurisdiction to set the avoided cost rate. The avoided cost rate should be based on an electric utility system cost data and account for factors that are specified in FERC's regulations, such as contract term, anticipated reliability of the facility, impact of losses, et cetera. And finally, as noted previously, electric utilities that are all requirements power supply customers may elect to use the avoided cost rates of their suppliers. Additionally, electric utilities and QFs are free to negotiate a rate other than avoided costs, but nothing obligates the electric utility to pay a qualifying facility more than its documented avoided cost rates. In addition to the must-purchase obligation, electric utilities are obligated to make power sales of energy and capacity to QFs at just and reasonable rates that are non-discriminatory relative to similarly situated customers. QFs must also be provided with supplementary backup maintenance and interruptible power. Under PURPA, QFs also have the right to interconnect electric utility systems as may be necessary to accomplish power purchases or sales. Electric utilities can require QFs to pay reasonable interconnection costs, such as metering and the cost of any transmission or distribution system upgrades that may be necessary to facilitate the interconnection. But again, it's critical that any such costs be non-discriminatory and comparable to what would be assessed to any other interconnecting resource or load. Finally, other electric utility obligations under PURPA include transmission, providing transmission to other electric utilities if the QF agrees and wishes to wheel power over the electric utility system to another utility. You may assess a rate to the QF for that transmission service. Finally, electric utilities are required to offer to operate in parallel with an interconnecting QF subject to any applicable reliability requirements. So with that very brief overview of PURPA, let's begin our discussion of current issues. Rebecca's going to kick that off.
Thanks, Meg, and thanks everyone for joining us today. Utilities are facing a number of current issues related to the implementation of PURPA, and both FERC and Congress are taking a look at these issues and questioning the need for PURPA in its current form. In June 2016, FERC held a technical conference in docket number AD 1616, which focused on implementation issues under PURPA. The technical conference addressed current topics, including issues related to the mandatory purchase obligation, the 1 mile rule, minimum standards for PURPA purchase contracts, including minimum length, and avoided cost calculations. And Meg and I will be addressing some of these issues in more detail as we go on with the presentation. FERC has not taken any further action in this area since the technical conference. Despite FERC's activity in this area, however, the consensus among new FERC Commissioner Robert Powelson and nominee Kevin McIntyre, who has been confirmed by the Senate but not yet sworn in, is that changes to PURPA must come from Congress rather than FERC. Chairman Chatterjee has also shared this opinion, but in recent remarks made at the Energy Bar Association's Mid-Year Energy Forum, he highlighted that FERC has discretion as to how it implements PURPA. Chairman Chatterjee noted that he believes that the Commissioner should continue with the progress started at the 2016 technical conference that I noted in 801616, docket number 801616, to determine whether changes in FERC's existing PURPA regulations and policies are needed. Chairman Chatterjee specifically noted that parties at the technical conference indicated a need for a different approach to the 1 mile rule for qualifying facilities. Like FERC, Congress has addressed the need for PURPA reform. In a November 2015 letter to FERC, Senator Murkowski and Congressman Upton and Whitfield explained that since PURPA was enacted, competitive electricity markets and open access policies have expanded the markets for renewable energy resources. A February 2016 letter from Senator Cantwell and Congressman Pallone and Rush notes that state policies are driving growth in renewables such that PURPA is effectively dormant. However, they also noted that PURPA acts as a backstop to support renewables in parts of the country where they may face barriers. More recently, in September, the Committee on Energy and Commerce held a hearing to reevaluate PURPA's objectives and its impact on consumers. The catalyst for this hearing was the fact that there have been significant changes in the power generation sector that may necessitate revisiting PURPA's objectives and determining whether revisions would be appropriate at this time. Specifically, the development of electricity markets, open access policies, state policies on renewables, and lower cost technologies, as well as the fact that renewables now play a significant role in the fuel mix, led to the determination to hold this hearing. The hearing solicited the views of industry stakeholders, including representatives from Xcel Energy, the Solar Energy Industries Association, the Idaho Public Utilities Commission, and Alliant Energy, among others. Similar to the FERC technical conference that I discussed previously, this hearing focused on issues such as the 1 mile rule, avoided cost calculations, term for contracts with qualifying facilities, and utility planning issues. Most recently, just at the end of October, 17 members of Congress sent a letter to Chairman Chatterjee of FERC urging FERC to update its PURPA regulations. This letter focused on the need to reform the 1 mile rule due to purported gaming concerns. The letter asks FERC to, this is a quote from the letter, to use its authority to undertake needed modernization of the Commission's PURPA 1 mile rule regulations while taking into consideration non-geographic factors as well. With that, I'll turn the presentation over to Meg, who will begin a discussion of our current issues that FERC and Congress are considering, beginning with the 1 mile rule.
Thanks, Rebecca. And before we launch into that, we have our second code word here. So again, if you're seeking CLE credit, be sure to write that down. As Rebecca just mentioned, the PURPA 1 mile rule is receiving pretty significant attention from legislators and regulators. This is a function of potential gaming concerns with respect to QF development and siting, as well as just general concerns that the rule in its current form may not be workable. So when we're talking about the 1 mile rule, what do we mean? Well, going back to the 80 megawatt size limit for small power production facilities, the 1 mile rule is a rule established by FERC and its regulations as a check on whether small power production facilities really meet the 80 megawatt size limit. As explained in the regulations, FERC will essentially aggregate any qualifying facilities that use the same type of fuel, have the same owner or are owned by affiliates, and are located at the same site. What does at the same site mean? Well, FERC addressed this in its regulations too. Facilities are deemed to be located at the same site if they're located geographically within 1 mile of each other. The 1 mile measurement is taken from the electrical generating equipment of a facility. Within the context of a wind facility, for example, the measurement means 1 mile turbine to turbine. The 1 mile rule is applied by FERC as a bright line rule, and this is some of the frustration I think that the industry is expressing with regard to the 1 mile rule. It's very inflexible. This rule isn't a rebuttable presumption. So this means that other factors, such as the location of a gen-tie line relative to an array of turbines, for example, or the location of a common collector station, doesn't impact FERC's analysis of whether the 1 mile rule is satisfied or not. FERC focuses purely on the distance between facilities. If the 1 mile rule if a facility doesn't meet the 1 mile rule and it's larger than 80 megawatts as a result, then the facility is not a QF and it's not entitled to make sales to electric utilities under PURPA. In the event that there is a violation of the 1 mile rule, QF status is revocable by FERC, either on its own motion or upon the motion of an electric utility or other person that wants to challenge that particular QF status. FERC also has the discretion, however, to waive the 1 mile rule in appropriate circumstances. Cited on the slide is a case, the Wind Farms Limited case from the early 1980s, in which FERC agreed to do just that. In the wind farm case, I think there were 2 or 3 qualifying facility sites that were all geographically located within 1 mile of each other. However, the topography of the area where the facilities were all located made clear to FERC that the facilities were really separate facilities. I think in the wind farms case, we were talking about 2 or 3 different wind farms that were all located on different sort of mountain areas. Well, as noted, lawmakers and electric utilities have identified concerns with the 1 mile rule. Developers are likewise looking at alternate methods of applying that rule in certain cases. Earlier this year, developers involved in 2 projects proposed in requests for FERC certification a new methodology that they referred to as the weighted geographic center methodology. Under that methodology, you would calculate the geographic center of an array of wind turbines and measure the distance from that center to the center of other facilities located nearby. Under this approach, turbines could be within 1 mile of each other without violating the 1 mile rule. While these proceedings received a fair amount of attention from the industry earlier this year, FERC actually didn't end up reaching the alternative methodology in its order certifying these QFs. However, these proceedings underscore that we may see more alternative applications of the 1 mile rule as the industry continues to discuss possible changes to how that rule should be applied. Changing gears a little bit, from the 1 mile rule, another current issue involves the interplay between PURPA and avoided cost pricing and energy markets administered by independent system operators, or ISOs, and regional transmission organizations referred to as RTOs. Specifically, there may be a disconnect between, for example, energy market prices and electric utilities' calculated avoided costs. And low energy market prices makes financing projects challenging for developers. At this time, there's little directly relevant FERC precedent on the use of market pricing metrics in the calculation of avoided cost rates. There are states that we're aware of where some form of market pricing is accounted for in the calculation of avoided cost rates, and we've cited a few of those state orders there on the slide. We did want to highlight the Exelon wind decision cited there, where FERC actually rejected the use of a market price at a QF node as a measure of avoided costs. Although FERC seemed to do so because the price at the QF's nodal location was not an accurate measure of the electric utility's avoided cost to serve its load. What I take away from this order is that market metrics could be an acceptable way to establish avoided cost rates from FERC's perspective, but they have to still be a reasonable representation of an electric utility's actual avoided costs. So, for example, it may be an approach that's acceptable to FERC to use a market metric that would involve LMP at a load node, for example. Again, these issues are complicated, and absent further clarification from FERC, I would urge electric utilities to proceed carefully with respect to incorporating market metrics into avoided cost pricing. If market pricing is offered to a QF as a measure of avoided costs, electric utilities should be certain to continue to preserve the rights of QFs to enter into power purchase agreements pursuant to legally enforceable obligations with avoided cost rates set at the time of delivery or at the time the obligation is incurred. Also, with respect to ISO and RTOs, the Energy Policy Act of 2005 included some amendments to PURPA that pertain to market participation. Specifically, these changes allow electric utilities to terminate their obligations to purchase the output from QFs that are larger than 20 megawatts. This option applies primarily to electric utilities that are in ISOs and RTOs and are based on findings by the Commission that QFs located in these market regions have access to markets where they can make sales to any market participant, and therefore these resources do not need to rely on individual bilateral sales with electric utilities. We've seen a number of electric utilities take advantage of these changes derived from EPACT and have filed with FERC to terminate their PURPA purchase obligations. So we're going to turn back to Rebecca now, who's going to focus on some additional current issues. Rebecca?
Thanks, Meg. Another common issue many utilities are facing is whether they're required to purchase from a qualifying facility when they do not have a need for the capacity or energy produced by the qualifying facility. A qualifying facility's output may exceed a utility's total system load, especially where the interconnecting utility is a smaller system, which we see with many municipal utilities, for example. Even in the case where a qualifying facility's output does not exceed the utility system load, the utility may just not have a need for any additional energy or capacity because its needs are met by other resources. In that case, if the utility makes a claim that it does not need capacity from a QF, it may need to show cost data to demonstrate that claim, and if it's able to do so, if it's able to show that it has no need for the capacity, then the avoided cost for such capacity would be zero. In the City of Chatterjee case, which is cited here on the slide, the Commission explained that while utilities may have an obligation under PURPA to purchase from a QF, that obligation does not require a utility to pay for capacity that it does not need. So in the case where the utility does not need capacity, they would still be required to purchase, but the avoided cost rate would be zero. With regard to energy, unlike capacity, energy is presumed to be needed by the utility. If a utility does not need the energy, this can be taken into consideration when calculating avoided costs, but avoided costs are not automatically going to be zero as they would be with capacity. The Commission's regulations also identify those periods during which a utility is not required to purchase energy from a qualifying facility. Section 292.304F of FERC's regulations states that an electric utility will not be required to purchase energy or capacity in any period during which, due to operational circumstances, purchases from QFs will result in costs greater than those the utility would incur if it did not make such purchases and instead generated an equivalent amount of energy itself. However, despite this provision, FERC has placed limits on curtailment of energy from QFs. This is under Section 292.304F. The ability to curtail a QF's output is generally not available if the QF has opted to sell to the utility under a legally enforceable obligation rather than on an as-available basis, and this was discussed earlier in our background section. Therefore, utilities that are parties to long-term agreements with QFs with rates calculated at the time a legally enforceable obligation was incurred cannot curtail QF power pursuant to Section 292.304F. According to FERC in the Chatterjee case, which is cited there on the slide, the rates for long-term bilateral transactions with avoided costs calculated at the time the obligation was incurred already represent that each party took into consideration various changes in circumstances over time, such as periods of light loading. Now we have our third code word. Please be sure to write that down so that we can note your attendance for CLE credit. Moving on, another issue that has been important for utilities lately is contract duration for a contract with a QF pursuant to a legally enforceable obligation. FERC has not established a specific minimum or maximum contract term for contracts for a utility to purchase a qualifying facility's output. In a 2016 declaratory order issued in Wyndham Solar, which is FERC docket number EL16-115, FERC explains that while its regulations do not specify a particular number of years for a legally enforceable obligation, a legally enforceable obligation should be long enough to allow qualifying facilities reasonable opportunities to attract capital from potential investors. In this regard, utilities and QF resources have competing objectives when it comes to the duration of a contract pursuant to a legally enforceable obligation. A QF developer would seek to finance its project under a longer-term contract because a longer term would provide the developer with more certainty with regard to it receiving a return on its investment in the project. A utility, on the other hand, would likely seek to mitigate price risk with shorter-term commitments that would allow them to update the rate paid to the qualifying facility so that that rate would never exceed the utility's avoided cost at any given time. For example, a 20-year contract may lock the utility into a price that eventually would no longer match its avoided costs. As I mentioned, FERC has not established a minimum or maximum contract term, but a number of state regulatory authorities have addressed this issue and have addressed contract terms at the state level. For example, the Idaho Public Utilities Commission in 2015 granted a petition requesting that it reduce the length of prospective contracts from 20 years to 2 years. On the other hand, the Wyoming Commission rejected a similar request to reduce the utility's PURPA contract term from 20 years to 3 years. And recently, in 2017, North Carolina adopted PURPA legislation that reduced the mandatory PURPA contract term from 15 years to 10 years. So given these examples, it's clear that contract duration is not consistent state to state. Utilities, among other issues facing them with regard to their PURPA purchase obligations, they have to deal with a number of planning challenges when trying to incorporate the output from qualifying facilities into their long-term planning. As an initial matter, we note that the current planning environment is challenging in general, even without considering the additional layer of complexity that PURPA would add to that. Demand may be relatively flat. Behind the customer meter, distributed generation leads to reduced demand, and utilities are also competing with retail choice policies in certain states. These elements all introduce a degree of difficulty in planning long-term. When you add PURPA obligations on top of that, utilities face an added layer of unpredictability. For example, as I've already described, QF's project may be large relative to the size of utility's load, or it may exceed the utility's load. Electric utilities also are unlikely to know where or when QF development may occur, and thus they can't really include the output of the QF in their long-term planning. Another question facing utilities is whether an electric utility's power requirements contract would supersede its must-purchase obligation under PURPA. And this issue was addressed in 2015 in the Delta Montrose case, which is cited on the slide. In that case, Delta Montrose Electric Association had executed a wholesale electric service contract with Tri-State Generation and Transmission Association in 2001, pursuant to which Tri-State was responsible for meeting at least 95% of Delta Montrose's needs for capacity and energy. The contract did not expressly provide that Delta Montrose had the right to purchase electric energy from sources that it didn't own or control, which included purchases from qualifying facilities. In that order, FERC determined that despite the terms of this existing power supply contract, an electric utility is obligated under PURPA and the Commission's regulations to purchase power from any qualifying facility that can deliver power to the electric utility. In that order, FERC relied on Order number 69, which stated that if contractual devices were permitted to allow electric utilities to avoid the purchase obligations, those contractual devices could be used to hinder qualifying facility development. Also in order number 69, which as you may recall from earlier in the presentation is FERC's order implementing PURPA, FERC also stated that the must purchase obligation supersedes any contractual restrictions on a utility's ability to obtain energy or capacity from a qualifying facility. So based on order number 69 and on the Delta Montrose case, a utility that is a full requirements customer of another utility would not be relieved of its purchase obligation based on its commitment to purchase from that supplier. Related to the question that I just discussed of the obligation to purchase despite existing contract obligations is whether, when an all requirements customer must purchase from a qualifying facility, can the all requirements supplier recover lost revenues? In order number 69, FERC allowed the supplier in that type of situation to recover lost revenues directly from a customer utility purchasing from a QF. In that case, the customer utility could then reduce the avoided cost it paid to the qualifying facility by the lost revenue adjustment it was required to pay to its supplying utility. However, in 2016, FERC denied a request to do just that, to implement a billing provision that would allow a requirements supplier to recover lost revenues due to requirements customers' purchases from QFs. FERC determined that the discussion of that issue in order number 69 was in the context of pre-PURPA all requirements contracts between supplying and customer utilities, which at that time, because they were pre-PURPA, could not have anticipated what Congress or the Commission would do with regard to PURPA down the road. FERC also found in the Tri-State case that allowing such a provision would undermine its prior orders, specifically its order in Delta Montrose that I discussed previously, that an all requirements customer is required to purchase from a qualifying facility despite contract obligations, and that it would limit a QF's ability to sell power at a negotiated rate. There's currently a request for rehearing of this order pending, so we would recommend watching this to see whether the new commissioners will uphold these determinations. Looking ahead, as we've described, the industry, Congress, and FERC are all taking a look at PURPA and whether any reforms are needed. Certain issues may be resolved at the FERC level, while others may require legislative action. For example, FERC may address the 1 mile rule, market pricing, and curtailments, while legislative action would be needed to reform the size threshold, limitations on the must purchase obligation, the expansion of terminations, and to determine more generally whether PURPA is still needed to serve its original purpose. In this regard, we would recommend following both the docket for the FERC Technical Conference, which I've noted previously is FERC docket number AD 1616, and also to stay up on any legislative activity in this area. With regard to the FERC proceeding specifically, we may see a notice of proposed rulemaking issued in the Technical Conference docket. If that occurs, the Commission will seek comments on the proposed rule, and you'll have an opportunity to get involved and provide feedback if you wish. At the legislative level, it may also be worth reaching out to your representatives and providing feedback with regard to any issues that may impact your entity. So it remains to be seen what will be done in either the FERC or legislative arenas and what changes will come from any PURPA reform. So we recommend staying active and keeping up with these issues in both levels.
And this is Meg here. We do have one question that has come in. And the question is, what are the top reforms of PURPA that you would like to see? And I'm happy to share my thoughts on that, and if others have a different perspective, feel free to jump in. But I think obviously one area where I expect that there may be significant activity at FERC is obviously the 1 mile rule. There's been a lot of discussion at various levels of government with Congress and among the new FERC commissioners, as well as with participants in the industry who have concerns with the 1 mile rule, how it's implemented, how it's structured, whether it's really practical. And so that's one area where I think there would be, that I think is really ripe for FERC to issue some further guidance. I would actually also like to see some further FERC guidance regarding the use of market metrics in avoided cost pricing. I think there's a lot of uncertainty in that area, and I think some policy guidance from FERC would be extremely useful for both state regulatory authorities that are responsible for overseeing avoided cost pricing at the state level, as well as for non-regulated electric utilities, knowing how to incorporate those market metrics into how they do their rates.
I'd echo the reforms that Meg has mentioned. I think that both of those issues are very important and would benefit from reform or additional guidance from the Commission or Congress as applicable. I'd also like to, I think another area of reform that would be useful to see would potentially be the contract duration issue. Right now, I think that issue is a little foggy at the FERC level, and a number of states, as I noted, have addressed this issue, and I think that while you can look to that guidance, things are a bit unclear right now for utilities and for qualifying facilities in this regard.
We have another question that has come in. I think this is a question that's this is a challenging one. The question is, what are the implications of possible tax legislation and changes to the production tax credit on PURPA reform? And I think the answer to that is that it's really too early to predict where we may go as a country with some of the tax reforms that are currently being discussed, and I don't think I'd be able to weigh in on what may happen there. On behalf of Thompson Coburn, thank you so much for joining us. If you have any questions, please don't hesitate to reach out to any of us. We'd be happy to discuss some of these issues with you in more detail. Another question came in. The question is there any place to find QF rules by state? I wish there was an easy way to locate what those rules are, because both Rebecca and I and Peter have all tried to look for places to find different state policies in order to draw comparisons, and we're not aware of any one particular site that we'd endorse that or point people to that would include sort of a survey of that. I can say that just based on my own personal research experience, some state commissions are better than others in terms of publishing information and making the policies more comprehensible. And the follow-on is, or state-specific PURPA contract policies. Yeah, same answer. It's pretty challenging to do that state research, and there's wide variation on the information that some states make available. Certain states have pretty concise, easy to locate information online, just on their websites. In other instances, we really have to dig into the individual orders. Okay, so with that, thank you once again. We really appreciate your participation. And if there are any follow-up questions at the conclusion of the webinar, please don't hesitate to reach out to any of us. Thank you so much, and goodbye.